Oh, I feel lonely here because I only see my picture here. I don't know what's happening. Yeah, it's just my picture on the system. I don't see other colleagues. Do you mind? Can you just let me adjourn for a minute? Let me call my secretary to assist me.
Thank you.
Let's adjourn just for 1 minute. Just Sutherland.
Can Judge see you?
Can you see me, colleagues?
I can see you.
Okay. Can you switch on your mic, your camera?
Judge Sutherland and then
My camera is on, as far as I'm aware.
Judge Victor, is also your camera on?
Yes, my camera is on.
Where is that now?
We're just trying to fix. Great.
Yes.
Yes. Yeah, now I feel comfortable. Okay. Yes, Mr. Gilbert Marcus, you've put yourself on record that you are appearing for the judges of the Constitutional Court. Thank you.
Correct, my lord.
And can other counsel also just put their name on record who are appearing in the matter?
And Hlophe, you're muted.
Apologize. My lords, my lady, I appear together with Mr. Shai on behalf of Judge President Hlophe.
Sadiki. Let's see with Judge President. Okay. Thank you, Mr. Sidaki. And for the Freedom Under Law, who's appearing?
Thank you, my lords, my lady. I appear together with Ms. Palmer and Mr. Mohapi on behalf of Freedom Under Law, Max du Plessis.
Okay, thank you very much.
My lords, my lady, I appear, it's Salukazana. I appear on behalf of the JSC. I'm merely on a watching brief.
Okay, Salukazana, watching brief. Watching brief. Yes, thank you. As you all know that my colleague, Deputy Judge President Sutherland, has been case managing this matter. And today, we are mainly going to hear the application to intervene by Freedom Under Law and also the Rule 30 application that has been filed by Judge President Hlophe. And so as far as the matter of Advocate Marcus is concerned, that application is not opposed.
That is correct, my lord. My lord, my sole purpose of being here this morning is simply to ask your lordships and your ladyship to grant an order in terms of prayer 1 of our notice of motion. You will find that at case lines 009-2, and your lordship is absolutely correct. There is no opposition, and indeed the Judge President has filed a notice of non-opposition, which you will find at case lines 009-24. So, my lords and my lady, I would merely respectfully submit that there is indeed a proper case for our intervention. It is not opposed, and hence we seek an order in terms of prayer 1 of our notice of motion.
Okay. Advocate Siddiqui, do you have anything further to say?
I confirm, my lords, my lady, that the application by the justices of the Constitutional Court is not opposed.
And Advocate Duplessis, anything to say?
No, we are neutral as to that. Thank you.
Okay. DJP Sutherland, do you agree that the order should be granted? And Judge Victor?
I agree, DJP.
Agree.
Okay. We therefore grant an order in terms of prayer 1 of the application by the judges of the Constitutional Court.
I'm indebted to your lordships and your ladyship. With that, may I be excused?
You are excused, Mr. Marcus.
Thank you, my lord.
Thank you very much. Right. As far as the outstanding applications are concerned, we looked at the papers, we perused the papers and the heads of arguments that have been presented to us. And we are of the view that the two interim applications should be dealt with together. And then that in those two applications being dealt with together, it would be convenient if Mr. Siddiqui, you'd be the first to start, and thereafter Advocate Duplessis would present his arguments, and Advocate Siddiqui, thereafter you'll proceed with your reply. Having looked also at the issues raised in the matter, we think that we'll give you 1 hour to argue and 1 hour to Advocate Duplessis, and the reply would be 30 minutes. I just want to check with you if maybe you've got any comment to the procedure that I've just set out. Advocate Siddiqui?
Judge President, Deputy Judge President, my lord, I was not quite clear. Would my learned friend start with the application to intervene and then deal with the Rule 30, and then I would come after him?
We thought it convenient that the two applications be argued together, and
Yes.
then you should start with the arguing of your Rule 30 and also comment on the application to intervene. And later, after your colleague has argued, you'll be given an opportunity to reply, because Advocate Duplessis also filed one set of heads of arguments. So he'll present his argument after you shall have argued the two applications before us today.
I'm content with that arrangement, my lord.
And also the time you think you'd be able to ventilate all the issues in that hour, the first hour that we're giving you.
I shall get going, my lord.
Or it may even be less, or maybe were we too generous? Okay, Advocate Duplessis, do you have any comment to the procedure that I've just set out?
No, thank you. We're happy with that arrangement. Thank you, my lord.
Okay, thank you very much. Unless my colleagues want to say something, I think we should then proceed with the arguments.
Nothing to add, DJP.
Okay, thank you. Advocate Siddiqui, you can proceed.
Thank you, my lords, my lady. There are two applications, of course.
I said Siddiqui is Siddiqui. Sorry,
Siddiqui, that's correct.
Sorry to mispronounce your surname. You
Thank
can
you.
continue, Advocate Siddiqui.
My lords, my lady, there are, of course, two applications before the court. The first one we will deal with is that in relation to the Rule 30 application, in which we seek to set aside the replying affidavit filed by Freedom Under Law in the intervention application. It's respectfully submitted that the replying affidavit constitutes an irregular step which falls to be set aside. The causes of complaint in relation to the replying affidavit are as follows. In terms of section of Rule 25(2) of the Uniform Rules of Court, and no replication which would be a mere joinder of issue or bare denial of the allegations in the previous pleading shall be necessary. A replication need be delivered only if the plaintiff wishes to plead fresh facts in answer to the defendant. Proposition.
I missed the last portion that you said, Advocate Sidaki. You had freeze for a moment. Can you just repeat the last submission that you've made?
Thank you, my lord. Say a replication, of course, need to be delivered only if the plaintiff wishes to plead fresh facts in answer to the defendant's plea. And I say, my lord, that we provide authority for that proposition, the Mwelase case, in our heads of argument. Or rather, it's a part of the commentary from the Superior Court practice. Now, Rule 18.5, of course, provides that when in any pleading, a party denies an allegation of fact in a previous pleading of the opposite party, he or she shall not do so evasively, but shall answer the point of substance. This, the FUL replying affidavit fails to do. The applicant considered that the purpose of a replying affidavit is primarily to deal with new matters that have arisen in the answering affidavit, or to clarify those assertions in the founding affidavit which might have been misunderstood by the respondent. Where the respondent simply denies the allegation, it is not necessary to respond thereto by another denial or a repetition of what was said in the founding affidavit. And the authority for that is the Mwelase case we refer to. Now, Aram's acting deputy president of the Supreme Court of Appeal in Van Zyl and Government of the Republic of South Africa said the following: that a reply commenting on a reply similar to that we submit has been filed by FUL. A reply in this form is an abuse of the court process, and instead of wasting judicial time in analyzing it sentence by sentence and paragraph by paragraph, such affidavits should not only give rise to adverse costs orders, but should be struck out as a whole, even mero motu. We make reference to the case of Wingard and others versus Hlophe, where it was held that in application proceedings, the three sets of affidavits have a dual purpose. First, they constitute the evidence before the court and play the same role as oral evidence in action proceedings. And second, they define the issues, both factual and legal, which result in litis contestatio between the parties in the same way as pleadings in an action. Now, with these principles in mind, it was on this basis that the applicant then served FUL with the Rule 32B notice, affording FUL an opportunity of removing the cause of complaint for failing to act in accordance with the provisions of Rule 18.5. Of course, FUL declined the opportunity, and we submit that FUL's replying affidavit does not comply with the provisions of Rule 18.5, and as a result of which it does not fulfill the intended purpose of a replying affidavit, does not clarify the issues between the parties, and contains unnecessary repetitions. Now, of course, FUL then raised a point in limine in its answering affidavit to the Rule 30 application. Alleging that the rule application is defective in that it is based on rules that are not applicable to motion proceedings. According to FUL, an affidavit is not a pleading, and as such, its replying affidavit in the main intervention application did not have to comply with the provisions of Rule 18.5.
Mr. Sadiqi, so sorry to interrupt you. I just want to be sure that I understand the submissions that you are making. In application proceedings, can you file an exception to the founding affidavit or to a replying affidavit, like we usually do with a summons or a plea if it does not disclose the course of action?
My Lord, I would submit that that has become a practice in the courts. Of course, I do not wish to provide evidence from the bar, but I would say it has become practice in the courts. However, I submit that what the crucial point here is that Rule 18.5 says that a pleading must comply with its provisions.
Yes, I hear you there.
It's any pleading.
Yeah, you said that this is now the practice. Do you have any authority in terms of which an exception was filed to an affidavit instead of maybe a party seeking an application to strike out certain portions?
My Lord, I do not have an authority in relation to exceptions.
Okay.
However, my submission is that as Rule 18.5 provides, it relates to any pleading.
Okay, I follow your arguments.
Now, and the key question is, what is a pleading? Or is an affidavit a pleading? And we have at paragraphs 19 and 20 of our heads of argument address this particular issue. In relation to, firstly, it's a Supreme Court of Appeal judgment in Tiron and another versus Hlophe and others, where Wallace, as a Wallace Judge of Appeal, said that in application proceedings where the affidavits are both evidence and the pleadings. Now, we submit, my lord, that that clarifies a point that an affidavit is in fact a pleading. Now, when one goes through, when the judgment by Wallace Judge of Appeal in that Tehran matter is a majority judgment. There is a minority judgment to it, penned by Punan J.A. One will notice that in the judgment of Punan J.A., he approaches the matter as though an affidavit is not a pleading. However, he refers to authorities which say that the court has an inherent jurisdiction to, in appropriate circumstances, regard an affidavit as a pleading. And this particular dictum by Wallace J, writing for the majority, sought to put that whole debate to bed, where he said in categoric terms, affidavits in application proceedings serve as both evidence and the pleadings. We furthermore refer to, it's in effect two constitutional court judgments, also on this particular point. The one is Kem and others versus Electoral Commission, where the Constitutional Court made reference to an earlier judgment, that of Taba, where it had dealt with this particular point of, is an affidavit a pleading? And of course, the court said, as this court has held in Taba, questions of jurisdiction are to be determined on the basis of the issues identified in the pleadings, and in application proceedings, the affidavits represent the pleadings and the evidence. So we submit, my lords, my lady, that those cases of the Constitutional Court put the point beyond doubt that that an affidavit is in fact a pleading, and as Rule 18.5 says, it refers to any pleading and says a party, when in any pleading denies an allegation of fact in the previous pleading of the opposite party, he or she shall not do so evasively, but shall answer the point of substance.
Mr. Sadaki, may I ask you two questions? Do any of the cases which you referred us to make any express reference to Rule 18.5 when addressing the notion that a pleading can also take the form of an affidavit?
None of them, my lord, haven't found a case that refers directly to Rule 18.5. Yes. However, as I say, Rule 18.5 refers to any pleading.
Yes. Now I follow that. So your proposition, if I understand correctly, is that we must marry the dicta which you referred us to with the text in Rule 18.5. Now, if we embark on that exercise, are we at liberty to assume that the utilization of the text of Rule 18 was what the judgments had in mind when they referred to affidavits serving as pleadings. In other words, can we responsibly airlift the word pleading out of the judgments you've cited and then parachute that meaning into Rule 18.5 in order to give it meaning? Are we at liberty to do that?
My Lord, I would then refer to what I said earlier in relation to the Tiron matter, the Supreme Court of Appeal matter, where Judge Punan in minority judgment, although he seems to acknowledge that an affidavit might not be a pleading, but he then goes on to say that a court has inherent jurisdiction to deal with it as a pleading. And we say that in that minority judgment, Judge Punan was accommodating to having an affidavit regarded as a pleading, and that the majority actually felt you don't need to even accommodate it. It is if for want of a better phrase, a dead set rule that an affidavit is a pleading.
Isn't there a distinction which the judgments give rise to between an affidavit serving the purpose of a pleading and those dicta saying an affidavit is a pleading? Is that a material distinction to make?
My Lord, I would submit that looked at in context, of course, it would make sense for an affidavit to be regarded as a pleading, because otherwise, how is the pleading process regulated? If those provisions in those rules are not utilized for purposes of application proceedings such as this. And I'd ask the court to view it in that light.
Thank you.
My lords, my lady, I can see that I'm hopelessly running out of time, and I'm still.
No, you still have got about
half an hour.
40 minutes. You
Yes.
still have got about 40 minutes.
Am I at liberty, my lord, to ask for an extension?
I think you've got 40 minutes.
Yes.
I'll also remind you when you've got about 15 minutes, and then we can talk about an extension then.
All right. My lords, I think the crucial point in relation to the Rule 30 application is really, is an affidavit a pleading or not? I think once the court has accepted that, and I'm not going to delve into the rest of the arguments that we make in our heads of argument. I'm going to ask the court to take those into consideration in then saying, well, to the extent that the Rule 18.5 has not been complied with, then in terms of Rule 18.12, the respondent in this matter, or the applicant in the Rule 30, is then at liberty to launch an application in terms of Rule 30. And so we ask that we submit that in line with the dictum by Harams in Van Zyl, that FUL's replying affidavit stands to be struck out as a whole for failure to comply with the essential requirements of what should constitute a pleading in reply.
Before striking it out as you submit, shouldn't we also look at the question of prejudice?
Well, my lords, we address prejudice, of course, in the answering affidavit. We say that, I mean, to the extent that the applicant in the intervention application, there's such this paucity of information that was provided in its initial founding affidavit. Judge President Hlophe then provided a fulsome answer to the allegations, raising a whole lot of new allegations that cried out for a response. Now, and of course, the purpose of which is to elucidate issues, to work out what is denied, what is a common cause between the parties. As we stand here, Justices, it is not clear of the many serious allegations made by Judge President Hlophe whether, and on what basis those allegations are denied, and to what extent would he be required to deal with them any further. And we submit that in that is prejudice, in that the issues are not properly and clearly and articulately well defined in the matter.
Yes.
My lords, then I shall move on to the addressing the intervention application, on which I shall spend a bit of time. The issue in this matter concerns whether FUL has made out a case that it is liable to be joined as a respondent under Rule 12 of the Uniform Rules, or to be joined as a respondent in the public interest, or to be joined based upon any other ground. We examine the case made out in FUL's founding affidavit, for as a pleading, the founding affidavit must contain sufficient facts in itself upon which a court may find in the applicant's favor, and the applicant must stand or fall by his or her founding affidavit. And as was held in the Derby Lewis versus Chairman of the Amnesty Committee case, in application proceedings, the applicant's notice of motion and founding affidavit must contain all essential averments upon which the applicant's cause of action is founded, and must do so explicitly. And we underline, must do so explicitly. This principle has been affirmed in various and many other cases by the Constitutional Court. FUL's facts setting out its interest and standing are to be found in paragraphs 14 to 29, 94, and 95 of its founding affidavit. The high watermark of FUL's pitch to be granted standing is to be found in paragraph 24 of the founding affidavit, where it says, in the second line, I submit that both FUL and the public have a substantial interest in this matter and should properly be represented in these proceedings. At paragraph 25, the founding affidavit says FUL thus brings this application both in its interest as well as the public interest. At paragraph 26, it states, given the public interest in the matter, combined with FUL's historic involvement in the very matter, FUL seeks to be joined as a party to this case. The authorities make plain that the founding affidavit must contain essential averments upon which an applicant's cause of action is founded, and must do so explicitly. We now turn to what should have constituted those essential averments in the case brought by FUL. As regards the intervention in terms of Rule 12, the essential averments would be the following. First, that the applicant has a direct and substantial interest in the subject matter of the main application. Now, direct and substantial interest has been held to mean interest in the rights, which is the subject matter of the litigation, and not merely a financial interest, which is only an indirect interest in such litigation. We provide authorities supporting those averments, my lord. Now we submit that.
Sorry, can I ask you this? If UL wanted to be engaged as amicus, would that have made a difference? It's a hypothetical, but so if they have an interest to assist the court, that would your client have objected?
Well, my lady, a different set of criteria, of course, in relation as regulated by Rule 16A, would apply. But FUL has come back in its replying affidavit to state categorically that they do not wish to participate as an amicus. They only wish to participate as a party.
Yes, I understand that. But if one, then the second question I wish to put to you is that their mission statement, their very reason for existence is to attend or to address constitutional issues. Does that not give them a direct interest?
My lady, I shall deal with this aspect later on in my address, but I submit that the short answer would be, in this particular case, based on the facts that are applicable, on the evidence that's been presented and facts applicable to this case, our client would still have objected to FUL participating even as an amicus. But I deal with this in my address, my lady. Suffice to say that in terms of the requirements of Rule 12, direct and substantial interest is not pleaded in the FUL founding affidavit. Second, as was held in the amalgamated engineering case, the question of joinder should not only depend on the subject matter, but on the manner and the extent to which the court's order may affect the interest. That is the legal interest of the parties. The test is whether a party that is alleged to be a necessary party has a legal interest in the subject matter, which may be affected prejudicially by the judgment of the court in the proceedings concerned. Legal interest is said to exist when the order or judgment sought cannot be sustained and carried out into effect without prejudicing the interests of the party or parties not joined in the proceedings. Now, we submit that the averment that the order or judgment sought cannot be sustained and carried out into effect without prejudicing the interest of the parties not joined in the proceedings that allegation has not been made in the FUL's founding papers. The aforesaid requirements for intervention were upheld by the Constitutional Court in the SA riding matter. We refer to it in our heads of argument, where it was held, at paragraph 9, that it is settled law that an application for intervention must meet the direct and substantial interest test in order to succeed. What constitutes a direct and substantial interest in the is the legal interest in the subject matter of the case, which could be prejudicially affected by the order of the court. This means that the applicant must show that it has a right adversely affected or likely to be affected by the order sought. We submit that the founding affidavit does not set out explicitly, as required by the W. Lewis case, whether the intervention is sought under Rule 12 or under the common law. This court has been left to speculate. The founding affidavit makes no allegation that FUL qualifies to be joined as a necessary party or as a matter of convenience to the main application. Accordingly, these possible...
Sidake, on that point, when you filed your Rule 30 application, you don't challenge the founding affidavit. Do you agree?
That's correct, my lord.
Yeah. So the founding affidavit should stand.
No,
the contents of the founding affidavit should stand.
Well, the evidence of the founding affidavit, yes, would stand, my lord. We only sought by way of the Rule 30 to set aside the replying affidavit. Of course, the content of the founding affidavit would stand. However, when exploring that content, it is our submission that that content does not make out a case that FUL stands to be admitted as an intervening party in terms of Rule 12 or even under the common law.
In the main application, are the constitutional issues raised? In the main application by J.P. Hlophe?
In the main application, of course, there are constitutional cases raised. That's correct.
Okay, thank you. You may proceed.
Accordingly, these possible legs for joinder do not feature, we submit, as ingredients to the cause of action in the founding papers. No evidence has been put up to underpin any basis upon which FUL could be either a necessary party or joined as a matter of convenience, or that it has a direct and substantial interest.
Mr. Sidake, can I ask you this?
Yes.
You're confining your argument from paragraph 24 onwards. Are you asking us to ignore the assertions from paragraph 12 onwards, where they have an interest in constitutional democracy, if you look at their mission statement, and they want to strengthen the independence of the judiciary? So is that not an aspect that should be considered in terms of their having made out a case for an interest?
Certainly, my lady, but however, that is raised in relation to the public interest leg of their application. So on the one hand, they bring an application under Rule 12, and then on the other hand, they bring an application to be allowed to intervene. We surmise it's in terms of Rule 12. In fact, they seek to supplement this in the replying affidavit only. the first time that the FUL refers to direct and substantial interest is only in the replying affidavit and not in the founding affidavit. And that was only after Judge Hlophe had queried this in his answering affidavit.
So
now,
what about the facts set out in those earlier paragraphs? Do they not go to standing?
They go to standing. They use them to go to standing, but in relation to the public interest. And I shall be dealing with the public interest aspect just now, my lady. I'm sorry to be taking too long, my lady, to get to my points.
Yeah, Mr. Sidaki, according to the time allocated, you've got about 15 to 20 minutes.
Thank you, my lord.
Yes.
Now, it's apparent that the main aim, that is the kernel of FUL's intended participation in this matter, is to oppose as a respondent Judge President Hlophe's application to review the JSC decision and to vigorously defend the majority decision of the JSC. FUL's interest is clearly that Judge President Hlophe must be found guilty and impeached, whatever the circumstances. To this end, and as appears in the Rule 53 record, volume 13, it's paginated number 49 to 53, FUL has even approached the Judicial Services Commission directly to participate in the JSC constitutionally mandated structures empowered to deal with the matter. The record shows that at the meeting of the JSC held on 4 June 2021, it was reported by the JSC Commissioner, Advocate Madonsela Senior Counsel, that FUL had sought to participate in the JSC deliberations as the JSC was setting out to consider the tribunal report under the auspices of Section 20 of the JSC Act. FUL also sought to make representations to the JSC and further sought to be provided with copies of written representations that had been made by the parties to the JSC. And of course, Judge President Hlophe, being the subject of that JSC process, was unaware of FUL's approaches to the JSC. The JSC refused FUL's requests to participate in its proceedings or to have access to its documents. No organization should be allowed, we submit, to usurp or be seen to usurp the functions of a constitutional body. Now, FUL, unlike the Constitutional Court justices, was not a complainant or any recognized party in the JSC process, did not play any formal role whatsoever in the multi-stage proceedings of the JSC in connection with this particular complaint and the resultant JSC decision. Accordingly, FUL has failed to meet the test to intervene under Rule 12 or the common law, we submit. It has not made out a case for intervention under Rule 12 or the common law in its founding affidavit. Now, relating to the requirements, essential averments to qualify to be joined as a party in a public interest, according to the authority Van Vinsen, dealing with actions in the public interest, the South African Law Reform Commission, in its report on the recognition of class actions and public interest actions in South African law, Project 88, published in August 1998. It defined a public interest action as follows. A public interest action is one brought by a plaintiff who, in claiming the relief he or she seeks, is moved by the desire to benefit the public at large or a segment of the public. Now, in this case, FUL is not seeking to be an applicant. FUL is seeking to be a respondent. Now, Section 38 of the Constitution provides that anyone listed in this section has a right to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. The persons who may approach a court are anyone acting in their own interest, etc., and anyone acting in the public interest. Now, keeping in tune with the principle established in the Darby-Lewis case, that the founding affidavit must contain all the essential averments upon which the applicant's cause of action is founded, and must do so explicitly. We submit that.
Mr. Sidaki, are you saying that FUL did not explicitly state that they are acting in their own interest and in the public interest in their papers?
My Lord, we submit that they have not alleged that FUL has not alleged that it is pursuing a right in the Bill of Rights, which has been infringed or threatened, and thus instituting proceedings for a court to grant appropriate relief, including a declaration of rights. Now, FUL's public interest standing in other cases, which has been recognized by courts dealing with those respective cases, we submit is not under question here. That standing was based on the facts of each respective case. It does not give FUL a blanket public interest standing in all cases. Now, Herbston and Van Vinsen also make reference, discuss under actions in the public interest, the case, the Locus Classicus Ferreira versus Levin, in which Justice O'Regan held that the provision of the Constitution which affords a right to act in the public interest needs to be interpreted in the light of the special role that the courts play in a constitutional democracy, and that considerations held to be relevant to determining whether a person is genuinely acting in the public interest include whether there's another reasonable and effective manner in which the challenge can be brought, the nature of the relief sought, and the extent to which it is of general and prospective application, the range of persons or groups who may be directly or indirectly affected by any order made by the court, and the opportunity that those persons or groups have had to present evidence and argument to court. Now, we submit that FUL has not invoked the provisions of Section 38 of the Constitution in its founding affidavit. In any event, it would not be competent in this case for FUL to do so, considering that FUL only seeks to intervene as a respondent, not as an applicant. FUL acknowledges at paragraph 17 of its founding affidavit that the JSC, as a body established by the Constitution and mandated to advise the state on any matters related to the judiciary and the administration of justice, and especially and specifically with regard to the appointment, removal, and discipline of judges, is especially tasked, the JSC is especially tasked with the role of protecting and promoting the independence and impartiality of the judiciary. Further, that the JSC's decisions, recommendations, and/or submissions regarding the appointment and removal of judges, therefore, go to the heart of judicial independence, impartiality, and accountability. Now, FUL also acknowledges at paragraph 19 of its founding affidavit that Judge President Hlophe has been found by a specialist body mandated to regulate the judiciary to have committed conduct which amounts to gross misconduct. We underline the words specialist body mandated to regulate the judiciary. Indeed, the JSC is such a body that has been assigned powers and functions by the Constitution and under the Judicial Services Commission Act. The tribunal, in terms of Section 26 of the JSC Act, conducts an inquiry into the allegations against a judge and submits a report containing its findings to the JSC. In terms of Section 20 of the JSC Act, the JSC must consider the report of the tribunal and make a finding, which is what happened in this case. We now know that following the submission of the Rule 53 record, that at the JSC meeting held on 25 August 21, the JSC finding that Judge President Hlophe was guilty of gross misconduct was reached by a majority of 8-4. Thus, it is the decision of that specialist body, a functioning constitutional body, that Judge President Hlophe has exercised his rights, among others, under Sections 33 and 34 of the Constitution, to launch the review application. In this instance,
sorry to interrupt you. You've got 10 minutes. Do you think you'll be able to wrap up in 10 minutes, or are you going to need more time?
I'm going to soldier on, my lord. I'll try to complete in 10 minutes.
Okay. Thank you. Proceed.
We submit in this instance the public interest vests in the Judicial Services Commission as a constitutionally mandated body, in the words of FUL, tasked with the role of protecting and promoting the independence and impartiality of the judiciary, and as a specialist body mandated to regulate the judiciary. FUL has not alleged that the JSC has failed in its duty to execute its functions. This Honourable Court has to weigh up whether the controversies which FUL brings with it to this matter, as set out in Judge President Hlophe's answering affidavit, which have not been controverted, that is, the truth of the content of which has not been gainsaid, would assist FUL's claim to be acting in the public interest. To this end, can an organization which has been shown through the actions of its representatives at the highest level to have acted in a manner that seems to undermine confidence in the judicial system be entrusted in the same case with the advancement of the public interest? The content of the Friedrich Naumann Foundation interview is a case in point. To preserve the dignity of the courts and all concerned, and to act with Ubuntu, we propose not to traverse its ugly content, but ask the court to have regard thereto, unless the court would, of course, prefer us that we deal fully with the issues arising thereto. We submit that FUL raises for the first time in heads of argument the issue of previous heated exchanges in 2008 between Judge President Hlophe and the justices of the Constitutional Court. That matter has been ventilated in the courts and in the JSC's Judicial Conduct Committee. It was finalized almost a decade ago in 2012. However, FUL disregards this by referring to it again, and it has disregarded this, we submit, with impunity. It is not suggested at this stage that the tribunal or the JSC were in fact influenced by the statements made in the interview. However, the point being made is that this has been left to such speculation, and we submit it has been left to justifiable speculation. The aphorism, justice must not only be done, but must be seen to be done, is apposite here. It is important to consider how this aphorism came about. It was in the case of the King versus Sussex Justices, ex parte McCarthy, before the King's Bench division in 1923. In that matter, Mr. McCarthy was charged for having driven his vehicle in a manner that was dangerous to the public. It transpired at a later stage that at the hearing of the matter, the acting clerk to the justices was a member of the firm of solicitors who were acting for the other party in the case against Mr. McCarthy. At the conclusion of the leading of the evidence, the justices retired to consider their decision, with the acting clerk retiring with them in case the justices should desire to be advised on any point of law. The justices convicted Mr. McCarthy. Upon a subsequent appeal by Mr. McCarthy, it was stated on affidavit that the justices had reached their decision without consulting the clerk. Lord Hewitt delivered his judgment on November 9, 1923. He held that he fully accepted the statements contained in the affidavit of the Sussex justices. He also accepted that the presence of the clerk did not influence the decisions and that the clerk did not participate in the justices' deliberations. Lord Hewitt also assumed and accepted that the deputy clerk had scrupulously abstained from referring to the case, which his law firm had been engaged to pursue the claim for damages against Mr. McCarthy. However, despite accepting these facts and also the fact that the conviction was not influenced by the presence of the clerk, Lord Hewitt quashed McCarthy's conviction, observing, "It is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done." Lord Hewitt went on to observe that the question was not whether the presence of the clerk had influenced the decision or whether his firm, being involved in the case, had any role to play in the conviction. Further, that what was important was not what was actually done, but what might appear to have been done, and then held, nothing is to be done which creates even a suspicion that there has been an improper interference with the cause of justice. Now, Chief Justice Mohammed, in a speech published in the South African Law Journal, we refer to it in our heads of argument, said the following: "What judicial independence means in principle is simply the right and the duty of judges to perform the function of judicial adjudication through an application of their own integrity and the law, without any actual or perceived, direct or indirect interference or dependence on any person or institution." We submit that the dangers embedded in FUL's insistence on having itself involved in this matter, taking into account the controversies in the papers, run to negate the statement that I've just quoted from Chief Justice Mohammed. We submit this matter presents a cacophony of ironies And when this court considers it, it will be confronted with this cacophony of ironies. We submit that no proper case has been made out for FUL's intervention as a respondent in this matter on any ground, be it under Rule 12, the common law, or even on the public interest leg. We respectfully ask the application to be dismissed. Judge President Hlophe does not seek costs in both these applications. Justice, my lady Justice Victor, I'm not sure if I covered your questions in relation to public interest in my address.
Yes, you have. Thank you very much, Mr. Sidaki.
Unless the court has any further questions to ask, those are my submissions. Thank you.
Okay. Thank you, Mr. Sidaki. My colleague Sutherland.
I have no further questions. Thank you.
I've got no further questions. Yes. It's exactly 1 hour. Thank you, Mr. Sidaki, for sticking to the time. And I take it that you have presented all the arguments that you wanted to give to the court.
That's correct, my lord. Thank you.
Okay. Thank you very much. I see it's now about 11:10, and it would be appropriate, I think, that we should adjourn for 15 minutes and we'll resume at 11:20 to hear the arguments of Mr. Du Plessis. Court adjourns for 15 minutes.
Yes, thank you.
I don't see Mr.
Here I am.
Duplessis. Mr.
He's there.
Is he there?
Yes.
There's something wrong with the system. Are you ready to proceed, Mr. Duplessis?
I am indeed. Thank you, my Lord.
Yes, you may proceed.
Thank you, my Lord. Well, my lords, my lady, we know that Judge Hlophe wants to shut the door on full being part of the main application. With respect, we say he would have to overcome 4 obstacles. Each of them alone, we say, is insuperable. And when taken together, with respect to him, they present an Everest of a mountain that he'll have to climb. And he wants to take us all along with him. With respect, in many respects, we say that the journey is an abuse. And I will, in 4 different chapters of my argument, sketch those mountains for the court, with your leave. By way of introduction, let me just say that we have seen a version of this play or this film before, at least in 3 different ways. The first is that, as the court will know, Judge Hlophe had tried to keep freedom under law out of previous cases where Fool's participation was critical, as it turns out, to the continuation of the complaint against him. And we know that the High Court and the SCA have said that Fool's standing was beyond doubt, and had it not been for Fool bringing those cases, the complaint may well have died. The second point on a replay mode is that the case involves, unfortunately, incautious claims that have been made against freedom under law and Judge Krechler by Judge Hlophe in this case. And similarly, incautious claims have been dismissed with punitive costs in a case in this division in freedom under law versus Jiba. And the third replay moment is that, with respect to Judge Hlophe, his claims against freedom under law and Judge Krechler are of a piece with his attacks against other accusers. We know that in this very case, he attacks members of the JSC, including very senior members of the judiciary, the judge president of this division, Justice Kampepe, and others. Previously, he attacked, when the complaint was first lodged, he attacked the justices of the Constitutional Court, including the Chief Justice and the Deputy Chief Justice. And he now is continuing that trend with respect in accusing the accuser, in this context, being freedom under law. That by way of introduction. If I might then be allowed to proceed directly to our argument. And as I say, there are 4 mountains which we say Judge President Hlophe will have to traverse. The first mountain is this. It's that the test for intervention in its constitutional setting, we say, is more than met in this case. I shan't take the court through the test. I'm sure that the court is well aware of it. We know that intervention may be granted where a party is a necessary party and it has a substantial interest in the subject matter of the litigation in which it seeks to intervene. It must have a prima facie case, and the application must be seriously made and must not be frivolous. Well, we with respect say that freedom under law meets that test more than adequately for 5 reasons. The first reason is, unfortunately, one I need to spend just a little bit of time on, arising from our learned friend's argument, and it's what is contained in the founding affidavit, because our learned friend has a very potted reading with respect to him of the founding affidavit. He has accepted, in answer to a question from his lordship, Mr. Justice Ledwaba, that the founding affidavit stands because there has been no objection to it. So there's been no Rule 30 objection to the founding affidavit. So the founding affidavit must stand as read. Well, in answer to a question by Her Ladyship, Madam Justice Victor, about whether the founding affidavit should be read only from paragraph 24 onwards, I think was the reference that our learned friend was giving. Well, we with respect agree with Milady. The paragraphs start way earlier. Our learned friend has failed to consider them and under the appropriate headings. Firstly, if one goes, and I know that the case lines references are here, but if 006-2, you just go to the founding affidavit, which speaks about it being under the heading of introduction and overview. You'll see that in that paragraph, or those paragraphs rather, the section introduction and overview, freedom under law makes it very clear that this case is about removal of judges and under Section 177 of the Constitution. It references that there are constitutionally ordained impeachment proceedings at paragraph 6 of the finding affidavit. And it says in paragraph 7 that Judge Hlophe seeks extraordinary, far-reaching interim relief, which contravenes the separation of powers doctrine. And he asks for a whole range of things which freedom under law contests at a constitutional level at paragraph 7 and 8. And I remind the court with respect that this finding affidavit by freedom under law at the time for intervention was drafted at a time when Part A still lay ahead. At that point in time, it wasn't clear whether...
Mr. Du Plessis, sorry to interrupt you. Can you please just increase the volume or just raise your voice a bit? I'm struggling to hear you.
I'll attempt to speak louder. How is that?
Yes, now this is good. This is good. Thank you.
And so what you will have seen, my lords and my lady, in certainly the first section of the founding affidavit is the sections of the Constitution implicated, the importance of those sections to freedom under law, the relief that Judge President Hlophe was seeking and why freedom under law regarded that relief as extraordinary, remembering that it wasn't only a Part B relief at that stage that freedom under law was drafting its affidavit, it was also in relation to Part A. And then, if one sees at paragraph 10, so my ladyship, Madam Justice Victor asked whether our learned friend shouldn't begin reading from paragraph 12 onwards. Well, in fact, we'd suggest much earlier, as I've suggested, and certainly from paragraph 10. You will see at paragraph 10 of the finding affidavit, it said, this is moreover not the first interaction of Full has had with the JSC and Judge Hlophe in the context of the complaints leveled against him, of attempting improperly to influence constitutional court justices. And there, really the background to Full and its involvement in this very case is set out. And it explains that it did so and was recognized as doing so in the public interest, as well as in the fulfillment of its own mandate to protect the rule of law. Our learned friend says that he's not sure where it is said in our finding affidavit that we're wishing to represent the public interest, or in fact, at one point, I think he also was confused as to where we'd said we were acting in our own mandate. Well, it's said clearly at paragraph 10. Paragraph 12, it's explaining who we are as freedom under law. The parties are set out. And then from paragraph 14 onwards, justices, you'll see it's under the heading intervention, Full's interest and standing. Our learned friend, Mr. Sadaki, says that in answer to the question from my lady, well, shouldn't we be reading paragraph 12 and so onwards? Our learned friend said, no, but that was just about public interest. Well, with respect, he's wrong. You'll see that the heading is intervention, Full's interest and standing. And I'm not going to take the court through each of those paragraphs. It's enough to recognize paragraph 14, we'd ask, which highlights what Full was established for, and that it specifically was established to defend the rule of law by way of instituting or joining in litigation. If you'll see over the page, 006-6 of case lines, you'll see that at the top of the page, in paragraph 17, Full says that the JSC's decisions, recommendations, and or submissions regarding the appointment and removal of judges go to the heart of judicial independence, impartiality, and accountability. That's the subject matter in dispute. That's what they have identified as what they're interested in as freedom under law, and of course tied to their mandate and the public interest. And in the next paragraph at 18 says, so too do the constitutional safeguards, which are then triggered as a result of the JSC's discharge of its mandate. And then in paragraph 19, you'll see it explains what has happened in this case around the question of judicial independence, impartiality, and accountability in relation to Judge Hlophe. And it cites paragraph 20 of the finding affidavit, cites what the Supreme Court of Appeal has already said as a conclusion around standing, notably that every South African citizen has an interest in this particular case. I won't read what the passage says, the court knows it. Over the page, and this is important with respect at 006-7, Full sets out its past litigation history, and it says at paragraph 21, it is previously litigated to set aside an earlier decision of the JSC, and it highlights that the SCA expressly determined that Full was acting in the public interest. And then it says at 22, Full has moreover addressed correspondence and engaged with the JSC from 2009 to date to inquire as to the progress of the complaints against Judge Hlophe A sample of such letters are next marked FA1. Those are ignored entirely by our learned friend with respect. I won't take the court through those letters, but the court will see that the final letter in FA1, I'll simply give to the court, with the leave of the bench, the page where you'll see at case lines 006-50. That's part of FA1, that bundle of correspondence. I shan't read it to the court, but it's 006-50. It's dated the 17th of September 2021. It's a letter by Freedom Under Law's attorneys, Weber Wenzel, to the JSC, inquiring about when are you going to take a decision. There was this previous decision by the Judicial Conduct Tribunal. You haven't yet suspended the Judge President. When are you going to be acting? And in that context, highlighting that its involvement and interest in the matter is not just historical, but is in fact ongoing all the way up until September in the history books, so to speak. If one goes back, and I have to unfortunately go back to the finding affidavit for really just the last minute or two, you'll see that at 006-7, going back to paragraph 23 of the finding affidavit, Freedom Under Law says that it is well versed in this matter and it has played a pivotal role in ensuring that the proper processes were followed. And then paragraph 24 is the important paragraph, because our learned friend says that it wasn't said anywhere by Freedom Under Law that it has a substantial interest in the case. He says it was said for the first time in reply. Well, let me just pause to say, of course, whether a party has a substantial interest in the case is a legal conclusion, in any event, for the court to draw from the papers. But as it turns out, in paragraph 24, it is said by Freedom Under Law, given that the decision involves the fundamental principles of judicial independence and impartiality, I submit that both full and the public have a substantial interest in this matter and should properly be represented in these proceedings. And over the page 006-8, and I can finish with this, full then says it brings this application in its own interest and in the public interest. And it does so to promote the independence, impartiality, and accountability of the judiciary. And it says that it's going to file as quickly as it can so that it doesn't delay the proceedings any further, the papers that it does. So, first point, very briefly, as to why we meet the test, is that the finding affidavit, in fact, expressly sets out all the reasons that are required for it to show its interest in the case. The second reason is it has a legal interest in the subject matter of this dispute, and that's confirmed by who Freedom Under Law is, by what the subject matter of the complaint entails, by what our courts have already found about this very saga, and by what Judge Hlophe himself says in his finding affidavit in this very case. If I might very briefly go through each of those 4 points. Firstly, who full is. I don't think I need to say to the court who Freedom Under Law is. It's set out clearly in our affidavit. And it says there that it is attempting to ensure this very subject matter as being something taken seriously by the courts and taken seriously by full through instituting or joining in litigation. That's its mandate. It does so in order, it says, to combat and correct institutional conduct in conflict with the rule of law. In other words, obviously, anything around this process, either by way of the Judicial Service Commission or the judges involved in the matter. It's therefore central to Freedom Under Law's mandate. The second point is the subject matter here. Full's interest in this litigation arises clearly from its public interest mandate. It flows from its mandate and the undeniable public interest in this application. And we know that that cannot be gainsaid because Full has participated in this litigation previously in the High Court, in the SCA, and in the Constitutional Court, and it was recognized in doing so in the public interest and in fulfillment of its own mandate to protect the rule of law. So the subject matter of what is before the court with respect, the questions of the JSC and removal of a judge who is alleged to be guilty of gross misconduct is at the heart of this dispute, and Freedom Under Law in relation to that subject matter has in the past litigated and has been recognized in that very context as being entitled to represent its own and the public interest. Thirdly, this is a serious case, and we know that because what our courts have already said about this saga and the importance of Freedom Under Law's role within that drama, so to speak. And I've cited for the court, or we've cited for the court already in our heads of argument, the decision of the Supreme Court of Appeal in 2011, and I shan't read it to the court. It's there for you to look at in your own time. But there, quite clearly, the court said freedom under law has in its own interest and in the public interest, it is an interested party that has the interests of this case at heart, and the court recognized those. And then fourth and finally, we know that freedom under law has a legal interest in this case because of what Judge Hlophe himself says in his founding review papers. The courts will recall that the JSC originally in 2009 finalized the complaint against Judge Hlophe without referring the matter to a formal hearing. That process was salvaged, as I say, by freedom under law's application to court and the eventual SCA decision, which said that the JSC had irrationally failed properly to investigate because it didn't allow for cross-examination. I think we all, as the lawyers in this country, recall that. But here's the point. A central feature of Judge President Hlophe's review in this case is he says that the 2009 finding of the JSC is correct and that there's no basis for the 2021 JSC decision. So if I might rephrase that, he's pulling into the very heart of his review the 2009 case that freedom under law was involved in. These are his words. I'll simply read them to the court. They're at case lines 001-51, paragraph 90. If I might just read to the court, if you've got the reference, 001-51, paragraph 90. He says, in a well-reasoned opinion of the JSC, I was exonerated by the JSC. He goes on to say, this opinion of the JSC is very important in assessing the rationality of the current JSC's findings against me. Essentially, he says, I've been found innocent and guilty by the same body on essentially the same evidence and facts. He goes on at paragraph 95 of his finding affidavit, that's case lines 001-53. So, Justice Sutherland, I see you reading 2 pages on at paragraph 95. He says, the SCA then eventually found against him, against the JSC, and held me liable jointly and severally with the JSC for fool's cost. And then the important paragraph, he says, the full import of this judgment in relation to the declaratory relief that I seek against the JSC will be made more clearly at the hearing of the application. So, with respect to Judge Hlophe, he has himself said that the 2009 process in which freedom under law was centrally involved is what he regards as central to his case today, as to whether there's a rational reason for the JSC to have come to the decision that it did. And if that's so, and he says the full import of this judgment in relation to the declaratory relief that he will be seeking will be made clearly at the hearing of the application, well, then freedom under law obviously has an interest in that. So the test, we say, for joinder has been met. We finish this point by stressing very briefly that given the subject matter, the public profile of this case, freedom under law's past involvement in the matter, and the critical importance of the administration of justice to all of us, it would also be in the interest of justice that freedom under law be admitted. And we reference in that regard the Constitutional Court's test on intervention, which was stated in ITAC versus Spore South Africa. So, no doubt, that is why we say all 4 of the respondents in the main application, of course, we include very important constitutionally mandated role players in this matter, such as the JSC, such as the President, and such as the Speaker of the National Assembly, have consented to freedom under law's intervention. They did so correctly. The holdout, of course, has been Judge Hlophe alone. That leads me then to the second mountain that Judge President Hlophe would need to climb with respect to him. And that is the test for standing, and what our courts have already said about freedom under law's interests and standing in relation to this case. As I've said already, the subject matter of this case goes to the very heart of our constitutional democracy. It's the paragon case, or a paragon case, of public importance and interests, and of what the Constitutional Court has described as constitutional litigation. Yes, it's absolutely the case that freedom under law had an election to make. Was it going to come in as an amicus, or was it going to come in as a party, as an intervening party? And I think Her Ladyship, Madam Justice Victor, asked that question of our learned friend. Well, revealing, of course, was our learned friend's answer. He said that even if freedom under law had applied as an amicus, they would have objected. But this is the point. Freedom under law had to take seriously its past involvement in the case. It had to do so, recognizing that it could well have an objection taken against it, that it was not permitted to come in as an amicus. And so, instead, it chose to come in quite correctly because of its history and because of its current involvement and its expertise in this area as a party. And in that regard, it took account of the Constitutional Court's decision in Outer. And if I might just, it's not in our heads, and I ask for apology in this respect, or I give an apology that we haven't referenced it, but it was, as I was listening to my learned friend on the argument around an amicus, that the judgment came to my mind. And the judgment is National Treasury and others versus Opposition to Urban Tolling Alliance and others. It's the Outer judgment, which I think the court will know well. It's 2012, volume 6, essay 223, CC. And it's critically helpful because there the DA had applied to intervene as an amicus against the appellant. In other words, as a respondent in the case, just as freedom under law is doing here. So the DA had attempted to intervene as a respondent in the case, as an amicus in the case. And it also, as an amicus in the case, wanted to argue that the appeal should not succeed, as freedom under law in this case wants to argue that the application should not succeed. And this is what the court said at paragraph 14 through the judgment of the Deputy Chief Justice Moseneke. It said this, it said there's a distinct difference between a party litigating to advance public interest in its own name on the one hand and propping itself up as a friend of the court on the other. Here, the Democratic Alliance has made common cause with the respondents and has strenuously urged us to dismiss the appeal. It is plainly the fifth wheel of the respondents. Its overall position is better suited to a litigant than a friend of the court. And we say, with respect, that's precisely the concern that animated freedom under law's decision. Yes, it might have attempted to come in as an amicus, but it knew, once it had seen the Judge President's papers and given its own involvement historically in the matter, that it wished to resist the application. And the moment it wanted to resist the application, then it was safer for it, with respect, to come in on the test set out by the Constitutional Court in Outer as a respondent. And as we know, had we attempted to come in as an amicus, our learned friend, Mr. Sadaki, very transparently says they would have objected anyway. The next point to raise very briefly on standing is this. Our learned friend seems to say that Section 38 of the Constitution is limited to you coming and approaching a court as an applicant. Somehow it means that we, as the respondent, or wishing to come in as a respondent, are not permitted to intervene. But that's just wrong with respect on the very wording of Section 38. It says any party wishing to approach a court. Well, we are. We're wishing to approach the court. In fact, we've filed an application in order to do so. We've an applicant in this very case. And we are approaching the court saying that we have standing in the matter for the interest considerations that I've already highlighted. And so standing is usually asked, yes, by an applicant. Can the applicant bring a case? But we submit that certainly there is nothing in the test that would foreclose the usual principles of standing and the generosity that the courts have recognized in constitutional litigation for parties being applied to freedom under law purely on the basis that it was coming in as a respondent. And so here's the obvious point. This case is, as I've said, the paragon of constitutional litigation. Critically, Full's place within that firmament has already been established clearly by our courts. And it suffices to mention just two judgments. The first is one which I have already referenced. That's the SCA's decision in Freedom Under Law of 2011. And with respect, it's a very strong bench. It's by a court composed of Streicher JA, Brunt JA, Kachalia JA, Turon JA, and Suriti JA. And it's quoted in paragraph 28 of our heads of argument. And I simply commend to the court paragraphs 16, 17, 18, and 19, and 20 and 21 of that court's judgment. Because it there references in this very context around this very dispute three things. And I'm simply paraphrasing the court's judgment in those passages. It firstly recognizes that the Constitutional Court has repeatedly said that there should be a broad approach to standing. And that's not only in relation to Section 38 Bill of Rights cases, it's also in relation to cases that fall outside of the Bill of Rights. I might just highlight in this regard that our learned friend was quite wrong with respect to him when he said that there needs to be a Bill of Rights or a right that Freedom Under Law had identified in order for them to be able to come to court under Section 38. That's simply not correct. The Constitutional Court in the JASA judgment, the judgment around the extension of the previous Chief Justice's tenure, specifically said that Section 38 is applicable as a broad understanding of standing to cases where fundamental constitutional principles are at stake, even where that falls outside of the Bill of Rights. And if I might just give the court the reference, it's JASA 2011, Volume 5, Essay 388, CC, at paragraph 17 and at footnote 18. So quite clearly, we would have standing, Freedom Under Law would have standing under Section 38, even though there's no particular Bill of Rights issue in this case. Although, of course, the independent judiciary is critical to the enforcement of the Bill of Rights more generally. But here there's a Section 177 case, and it's all about the administration of justice. That certainly falls under Section 38 of the Constitution and its broad understanding of standing, and the JASA case makes that clear. Furthermore, there is the decision of the Constitutional in the judgment in Nkabinde and another versus JSC, another judgment in this very matter and this saga. It's quoted at paragraph 13 of our heads. And the passage is from the judgment at paragraph 29, where the Constitutional Court ends its judgment. It ends its judgment in these words. It says, in conclusion, we would be failing in our duty if we did not take this opportunity to emphasize that it is in the interest of justice that the matter of the complaint against Judge President Hlophe should be dealt with and concluded without any further delay. The court says, in the end, it's in the interest of justice that this matter be brought to finality. Well, the passage with respect underlines precisely why Freedom Under Law is entitled to intervene here in the public interest. To resist Judge Hlophe's efforts to avoid accountability now, also before the National Assembly, and the need for finality to be reached. The JSC has chosen not to suspend Judge President Hlophe. And Judge President Hlophe has chosen not to step down voluntarily. So the need for finality, we say with respect, is heightened in this case. It's important with respect that Full is enabled to ensure through its arguments and its presence in the case that the matter reaches finality expeditiously and properly. Now, if I might turn very briefly to the arguments against us that are in our learned friends' heads, and I really wish to just pick out the central ones. We say with respect to them that their efforts to shut the door on Freedom Under Law really do flow from what we regard as a very one-eyed view of things. The first is that the Judge President insists on shutting the door only on Freedom Under Law, but yet he's consented to the intervention of the Constitutional Court justices. Oh, he says, but they've got a personal interest in the case. So Mr. Sadaki said, but they're complainants. They've got a personal interest in the case, and that gives them standing to join. And our learned friend also said that freedom under law has not been part of the JSC's process. Well, with respect, he would be wrong to advance that argument because of what the Supreme Court of Appeal has already said in the Freedom Under Law versus JSC 2011 case. And here, the passage from that judgment is paragraph 22, and it's quoted in our heads at paragraph 39.2 at page 21 of our heads. And it really is a critical passage because it not only highlights how wrong our learned friend's submission is, but it also highlights and underscores, we say, why it is quite obvious that freedom under law should be permitted standing here. Said the court, the Constitutional Court judges did not act in their own interest, and their complaint is not that they've been wronged in their individual capacities. They acted in what they considered to be the public interest. I therefore agree with counsel for the applicant's submission, that would be freedom under law's submission, that this is not a matter that can or should be left to the judges individually involved. They are entitled to act in their own interests and are not required to litigate in the public interest. They're also inhibited by the constraints of the reserve appropriate to judicial office, which renders them averse to involvement in public controversy. And then the critical lines in that paragraph are right at the end of them. One can also not expect individuals to call the JSC to account in expensive court actions. It is for bodies like freedom under law that can afford to do so, and whose very mission is to secure and strengthen the independence of the bench to take action. So our learned friend for Mr. Hlophe, for Judge President Hlophe, wishes to allow the Constitutional Court justices in, but with respect, the moment that is so, you need to read paragraph 22 of what the SCA has already said, and then one knows that freedom under law certainly should be permitted to come in as well. The one-eyed approach goes further. Our learned friends in their heads say that freedom under law is no standing to defend the JSC. With respect, it is a remarkable submission. They contend that our law recognizes in matters such as this, standing for an intimate circle of two people only. On their argument, only the decision maker, the JSC, has standing, and the subject of the decision, Judge President Hlophe, has standing. But that cannot be so. Cannot be so. As we've just seen, Judge President Hlophe does not oppose the intervention of other parties falling outside of that intimate circle, being the Constitutional Court justices. So to be consistent, Judge Hlophe must either let in full or he must keep out the Constitutional Court justices. You can't have it both ways. But the argument also comes undone with respect when you view it through the established rules of public interest litigation. On their argument, our learned friend's point is that only the JSC is permitted to bring this case. Freedom under law, they say, wouldn't have standing to bring the application, even if it had chosen to be an applicant, because they say freedom under law is not the decision maker, and because freedom under law is not the subject of the decision. Bottom line is, they say the JSC must defend its decision alone. Well, 2 points very briefly. Obviously, freedom under law could indeed have sought relief to set aside the JSC decision if it had gone the other way. So assume that the JSC had said it's not going to find the judge president guilty of gross misconduct. Freedom under law would have obviously had standing to bring an application to review that decision. We know that from the 2011 SCA decision, which of the SCA has already said that freedom under law would have had that standing. But in any event, public interest is not just held by the JSC. It's not, in the Harry Potter terms, it's not the golden snitch. Public interest isn't something to be held only by one person at one time. It can be held by numbers of parties and advanced by numbers of parties at the same time. I've just referenced for the court the JAS decision. And the court will remember that in that case, there were 4 different parties that rushed urgently to the Constitutional Court to set aside President Zuma's decision to extend the tenure of the Chief Justice. They were all different parties, all claiming to act in the public interest. There was, amongst them, there was JASA, there was Freedom Under Law, my client, there was KELS, and there was CASAC. All 4 of them ended up in the Constitutional Court, their cases being ultimately consolidated, all 4 of them asking that the president's decision be set aside, and all of them acting in the public interest. So there's absolutely nothing wrong with freedom under law alongside the JSC attempting to vindicate the public interest in this case. And in any event, we know third parties often make common cause with the decision maker or the subject of the decision. Often. Recently in the Zuma contempt proceedings, public interest entities either adopted Mr. Zuma's position and defended him, or similarly advocated for the position of the State Capture Commission. And in Mr. Zuma's rescission application of the contempt order against him by the Constitutional Court, the Helen Suzman Foundation intervened as a respondent party. A respondent party. And it did so to side with the State Capture Commission. I give to the court the citation that Zuma versus Secretary of the JSC, of the Judicial Commission of Inquiry into State Capture, 2021, volume 11, BCLR 1263 CC. And critically, you will see at paragraph 33 of the judgment, the following passage. HSF was admitted as an amicus curiae in the previous contempt proceedings, but was joined to these proceedings as a respondent. It opposes Mr. Zuma's application and seeks costs against him. So, with respect, there's nothing to our learned friend's argument that only the JSC is permitted to stand in defense of its own decisions. We are perfectly entitled as freedom under law to do so alongside them. Then, briefly, if I might turn to the third mountain.
Yeah, I can just indicate to you, Mr. Duplessis, that in terms of the time allocated, you've got another 20 minutes.
I will need probably less than that. You'll be happy to hear.
Right.
We say the third mountain is this, my lords and my lady, and that is that Judge Hlophe's real complaint, trying to keep freedom under law out, is based on speculation and what we say are incautious accusations. Effectively, we know that the argument is that freedom under law has supposedly deviated from its true constitutional course because Justice Crickler has spoken critically of Judge Hlophe on public platforms. Well, firstly, I mean, we say that with respect to our friends, so what? It's got no bearing on standing at all. And the premise of the allegation is false, is faulty. It seems to be that freedom under law must be shown the door because it's not neutral, because it has been critical of the judge president during this process. Obviously not. Its own interest in this case has been to protect the judiciary from the very conduct that it has said must be properly investigated, and which, following that investigation, has now confirmed its suspicions about gross misconduct by Judge Hlophe. It's not surprising that freedom under law, and to the extent that Judge Crickler is to be equated with it, which is not proper, but has done by Judge President Hlophe, to the extent that either freedom under law or Judge Crickler have said things critical about Judge President Hlophe, that's not surprising. Their entire case has been that there has been misconduct committed and that it needs to be properly investigated. Then there are the aspects around governance complaints in the past, in 2009. Well, that's all history. It has nothing to do with the present day question of freedom under law standing. And in any event, 2 years later, in 2011, the Supreme Court of Appeal said that there was no good reason to doubt freedom under law's standing in the case. And as has been said in the affidavit, Judge Crickler's views are not necessarily those of freedom under law. And of course, if there was a complaint that somehow about these past resignations, there was a lack of authority for freedom under law to bring this case, then that was the appropriate challenge to have been raised, but it wasn't. There's no challenge to freedom under law's authority in this case. It's not disputed that freedom under law and its board today have brought this case and are authorized to do so. And then come the abuses with respect. We've set them out in our heads at paragraph 34 onwards, and they're packaged. I'm not going to obviously go through them other than to highlight just 1 or 2 points. They're packaged in the affidavit by Mr. Tulu, which is part, we say, of something of an abusive trend to accuse the accusers. In this very case, as I started my address by highlighting, Judge Hlophe accuses senior members of the judiciary as being biased against him, including the judge president of this division, Justice Kompepe, and others. In this complaint, originally, he accused the Constitutional Court judges of being improperly motivated against him. And it's important to remember the words. We've referenced them at paragraph 35.1 of our heads. In addressing the merits of the Constitutional Court judge's complaint, Judge Hlophe accused the judges of impropriety, his word, and in particular it took aim at Chief Justice Pius Langa and Deputy Chief Justice Moseneke, impugning their motive and saying that the complaint against him was, again, his words, more likely an inexplicable desire to get rid of me, to get me impeached and to suggest that I'm not fit to be a judge anymore. And he accused them of an ulterior motive. And now, of course, he accuses freedom under law. Similarly, well, the picture is clear. Any person who is critical of the judge president is open for attack or vilification. But such a stance has been deprecated by our courts, and we've given to the courts the judgment of Mogami. It's useful because it's a case involving an attorney. Of course, its reference to an attorney should be pari passu applicable to a judge. And Harim's JA had the following to say about attorneys who, faced with claims of misconduct, chose to see every accuser as fair game for vilification. He said, it's a very serious thing to do so. It's become a common occurrence for persons accused of a wrongdoing, instead of confronting the allegation, to accuse the accuser and seek to break down the institution involved. This judgment must serve as a warning to legal practitioners that courts cannot countenance this strategy. And importantly, he says, in itself, it is unprofessional. Well, analogously, we want to also highlight for the court that in this division, a court had previously had occasion to criticize efforts by a litigant who, in seeking to intervene in a case involving freedom under law, chose to cast similarly wild aspersions against freedom under law and Judge Krichler. And the case we've cited for you in our heads, it's freedom under law versus the NDPP and others. We've cited it at paragraph 35.4 of our heads. And the judgment records the following in justifying a punitive cost award against the would-be amicus in that case, which was the Education for Social Justice Foundation amicus. And Mr. Sadaki's leader, Mr. Masuku, will be well aware of this case because he represented that amicus in the litigation. Said the court this at paragraph 85. In any event, the application is supported by a lengthy, argumentative, repetitive affidavit. The fining affidavit contains some unfortunate allegations which attack Full and persons associated with Full rather than Full's application. And said the court, those unfounded attacks attracted a punitive costs order. So we say it is unfortunate that these attacks have happened. They are of a piece with a trend of attacking the accuser. And in this respect, we say for that reason alone, the public interest is heightened in ensuring that there is a proper vindication of these issues, with freedom under law being able to assist in the case rather than being kept out on the basis of such an accusation. We've also set out in our heads very simply that history in this matter is important because of what it teaches us now. As we've said, in the 2011 SCA decision, Full's interests were confirmed and Full's involvement proved absolutely critical to the outcome of ensuring that the complaint against Judge Hlophe was properly investigated. And in this case, Judge Hlophe's case before this court in 2021 seeks to undo that outcome. Freedom under law, therefore, comes to this court and says, we wish to ensure that we are involved in protecting the process, in assisting the public, and ensuring that our own mandate, ultimately, through the history and ongoing in this matter, is given proper effect. So the entire case, we say with respect, against freedom under law is built on something of amnesia. This case by the Judge President forgets the history, forgets the cases against him, and ultimately forgets why freedom under law must be permitted to come in. There's a final mountain which I turn to, and it's the strikeout or Rule 30 application attempting to strike out the replying affidavit. And I wish to be brief on this. We listened to the debate with our learned friends, and of course, in the time remaining, I'm going to ask the court that I stand by everything we've said in our heads. We've already set out comprehensively why we say the application is defective and misguided. But I'll pick up some of the debates that we had with my learned friend, because really he doesn't get out of the starting blocks. As we know, the application is based on some or other lack of compliance with Rule 18.5, which is a rule regarding specificity in pleadings. And our learned friend invoked Tehran and Hlophe and the judgment of His Lordship Mr. Justice Wallace in the SCA. But with respect, His Lordship, well, there are three things to be said about that. Firstly, with respect, His Lordship never said that an affidavit is a pleading. He said it performs the function or serves the role of a pleading. So it's a fundamental difference. It doesn't make it a pleading for the purposes of Rule 18. And we know that because that's why you don't amend a replying affidavit by recourse to Rule 28. You can amend a replication. You can amend a plea. You can amend a particulars of claim by reference to Rule 28. But you can't amend an affidavit by reference to Rule 28. You can't even withdraw an affidavit without the leave of a court. And His Lordship, Mr. Justice Sutherland, made the second point, which is that those cases that have been referred to by our learned friend simply don't reference Rule 18 at all. They weren't talking about Rule 18 and whether it was applicable to affidavits. The third difficulty for our learned friend is that he would have to overcome the fact that the uniform rules are very clear about what the rules are applicable to affidavits in applications. They're contained in a rule we all know particularly well. It's Rule 6. Rule 6 deals comprehensively with parties' obligations regarding affidavits. Obviously, I shan't take the court through that. The court knows that. It sets out what affidavits must be, how they must be drafted, what they should contain, what the rules are by way of which the court considers the pleadings and the evidence contained therein in affidavits. That's Rule 6. Our learned friend would have it that Rule 18 is somehow also to be grafted into Rule 6. Well, his problems are not only what we've cited from Harms and from Erasmus, which speak about Rule 18 being applicable to pleadings in action proceedings. His difficulty is also that Rule 6.14, Rule 6 sub 14, specifically tells us when the other parts of the rule outside of Rule 6 are to be made applicable to actions as well as to applications. And it says in Rule 6.14 that only Rules 10, 11, 12, 13, and 14, ends at 14, doesn't go up to include 18, are applicable also to applications. Rule 18 does not have a similar stipulation. And it makes sense with respect, Lords and Milady. We're talking about applications. It's our bread and butter in the motion court. We know that applications entail parties drafting the affidavits, and you must make out your case in the filing affidavit. Our learned friend gave the candle away at one point. He said, without apparent irony, he said, the applicant's case for intervention stands or falls by what is set out in its founding affidavit. Well, exactly. And so that's where we had to make out our case. Judge President decided to answer. This court will determine on the basis of the usual rules on motion proceedings whether there was a sufficient basis for the Judge President to make the accusations that he did in the answering affidavit, whether they are supported by facts, whether they are just inferences unproved by any facts, whether they are outlandish and can simply be rejected on the usual test, and whether they do anything to dislodge freedom under law's basis for standing as set out in its filing affidavit where it had to set it up. This court will determine that. There's no prejudice to the Judge President by this court using the usual rules of motion court to determine the application one way or the other. And we know that there's a certain irony to this matter with respect, because the Rule 30A application that has been brought by our learned friends has been brought on filing affidavit. We answered it as freedom under law. Our learned friends haven't filed a reply. They know, with respect to them, they know that a case has to be made out in the filing affidavit. So what does the reply do in any event to the usual debates that a court has about whether the test has been met? So in short, we say freedom under law's reply, in any case, addresses all of Judge Hlophe's answers. And it does so by giving the answering affidavit the benefit of the truth. Freedom under law says, look, we don't think it's relevant. We don't think what you're saying is helpful. We think that you're muckraking. But even assume for a moment that it's true. Freedom under law's affidavit says it doesn't help to dislodge our right to standing. That's the approach that freedom under law explains that it has taken in its affidavit. And it says, given that treatment, a detailed point-by-point explanation was not required and didn't take the matter any further, because Judge Hlophe's position cannot improve on the papers. And he can argue, and he has argued, that there are various legal conclusions now based on his factual version. Well, that's his case, and he can make it. What he wants is he wants Judge Crickler to enter the fray and to defend statements that he, not freedom under law, may or may not have been made, when he isn't, as Judge Crickler, we've said, is not freedom under law, and his motives are irrelevant as a matter of law. And at the end of the day, they do nothing to dislodge what has been said repeatedly by the courts about freedom under law's standing. In short, and in closing on this point, if freedom under law is right as to the objective question of its standing, as we say it is, then nothing that it says in its replying affidavit is in truth of any real moment. And none of the attempted attacks by Judge Hlophe in his answering affidavit, which of course he now seeks to improve upon in his Rule 30 application by forcing responses from freedom under law, is of any assistance to that objective legal question. So we say that for that reason too, there's simply nothing to the Rule 30A objection, assuming, or 30 objection rather, assuming that it could get out of the Rule 18 starting blocks at all. Finally, I have to say that we are somewhat at a loss to understand the reference to the case 1923 and the King, because the suggestion, it seems to be, was that somehow there was a concern around Judge Crickler's statements which have now led to a perception problem. But that is unfounded speculation in numbers of ways. Firstly, I mean, it's not even proved by Judge Hlophe that anything that Judge Crickler said in the Newman address was even known to the Judicial Conduct Tribunal, that they were even aware of it. Secondly, what he said in January, many, many months before when they came to a decision, cannot possibly be suggestive of him influencing their thoughts or their decision-making. It's, with respect, an argument of abdication in the most extreme form. The suggestion must then be that somehow judges and senior lawyers who sat within the JSC and the Judicial Conduct Tribunal before that didn't bring their own independent minds to bear on the very serious question that was before them, didn't properly analyze all of the extremely lengthy evidence and submissions that was made before them, but somehow gave up their independent thinking in order to parrot what Judge Crickler had said in an interview many months before. With respect, it's risible. And so we say that that is, if that's the high watermark of their case against freedom under law in this respect and Judge Crickler, then it is, in truth, the low watermark. So for those reasons, we submit that the application is defective. In any event, in closing on this, it doesn't demonstrate any prejudice whatsoever. There's no foreseeable harm to Judge Hlophe, and none is identified. And as we say, it's also somewhat abusive if one regards the fact that our learned friends now say that there were new allegations that had been made, supposedly by freedom under law in its reply, and that somehow, therefore, the Judge President was prejudiced because he didn't get a chance to respond thereto. Well, that's a nonsense in light of His Lordship Mr. Justice Sutherland's decision in Akani, which we've cited in our heads, as His Lordship held recently in Akani at paragraph 51. When a litigant adopts the stance that there's new material in a replying affidavit, it can apply to file a rebuttal. It can also elect not to answer further. And if it does, it must live with its choice. In finishing off, my lords and my lady, Judge Hlophe had plenty of time to do so. He chose not to do so. Instead of dealing with any of this alleged new matter in reply, he elected to file a Rule 30 notice and an affidavit supporting this, and detailed heads of argument on that theme. and all with a view to insisting that the entire affidavit be struck out, not just those portions of it that he found supposedly lacking in specificity, but the entirety of it. That time could obviously have been used to draft a brief response to any of these alleged new facts or causes of action. So his refusal to do so, and now some belated cry of prejudice, simply, we said, indicates a desire to obfuscate and delay rather than to progress the matter. So in conclusion, we submit that freedom under law should be granted leave to intervene in the proceedings. It should be granted that on the basis of what it says is a necessary joinder. It does that with respect to the court on account of past judgments. It does so because of its own mandate. It does so because of the public interest. And it does so in relation to what is a critical case around constitutionally important values, which the courts previously have said freedom under law is purpose-built to litigate on. And we further say that Judge Hlophe's Rule 30 application is both baseless and abusive, and it falls to be dismissed. And in respect to both applications, freedom under law has sought the costs against Judge President Hlophe on a punitive scale. Those are our submissions, unless there are any questions from the bench.
DJP Sutherland, anything? You're muted, I did not hear you.
Forgive me, I have no questions, thank you.
I have no questions, thank you, DJP.
Thank you very much, Mr. Du Plessis.
Did I keep to my time? I hope I did.
Yes, actually finished a minute earlier, according to my record.
Thank you.
Mr. Sidaki, anything in reply?
Thank you, my lord. My lord, as regard the prejudice point that was just raised by my learned friend, I submit with respect that that is on the Rule 30 application. I submit with respect that certainly, I mean, the purpose of the pleadings is to is for the issues between the parties to be clarified, to be answered, to be clarified. Now, in this instance, the issues weren't clarified, and that in itself is a prejudice to Judge President Hlophe. I submit further that in relation also to the Rule 30 application, my learned friend submitted that in respect to Rule 614, he says it's only, he uses the word only, the provisions of only Rules 10, 11, 12, 13, and 14 would apply to applications. With respect, that's not, Rule 14 doesn't use the word only. It merely says those provisions apply to applications. It doesn't exclude the remainder of the provisions. Now, as relating to the Helen Suzman Foundation case, which my learned friend refers to, where the Helen Suzman Foundation had been admitted as an amicus in the main matter, where the HSF then participated in a subsequent litigation. We submitted it was in relation to the very same matter. So in the first matter, HSF had been admitted as an amicus in a review application, and the subsequent matter related to the contempt proceedings in relation to the very same case number, and the very same matter. So we submit that the two cases are completely distinguishable. In regard to this particular matter before us, FUL was admitted in 2009 in a different case, on a different basis, a different case number, and that matter was finalized in the Constitutional Court. And so when we deal with this matter, it's on the review application in this matter is on a completely different basis, and the issues that have been brought for review are also different. And so FUL would have to underpin its right to participate in these proceedings based on new facts, and those would have to be examined by this court anew. Now, my lords, my lady, Judge President Hlophe hasn't attacked FUL or Judge Krikler in these proceedings. He has merely set out a fact that there was an interview that took place, and he's brought that to the attention of this court, entered it into the evidence. But he hasn't attacked Judge Krikler or FUL. I submit it is incorrect to suggest that. There hasn't been an attack. There has only been a presentation of evidence of what exists out there concerning Judge Krikler speaking and invoking FUL in his speech. Now, our learned friend says, well, there's a distinction between Judge Krikler and FUL. If I may borrow that poetic license that he invoked to refer to Harry Potter, may I also use a contemporary phrase, is the Pope Catholic? I submit with respect that the distinction that our learned friend seems to want to make between Judge Krikler and FUL, I submit doesn't hold water, because Judge Krikler is a public face of FUL. He's the chairperson of that organization. He is its chief representative in public. Certainly, to suggest, and furthermore, Judge Krikler does say in his interview that he hopes that FUL agrees with his statements. Now, FUL has not dissociated itself with those statements. They've been given an opportunity to do so. They have not dissociated themselves with Judge Krikler's sentiments expressed in that in that interview. Now, furthermore, our learned friend, when referring to that interview, only makes reference to the resignation of the former directors. There are other aspects of it that are quite key to the determination of this matter. For instance, where Judge Krikler says, I've tried time and time again, publicly and confidentially, privately, to expedite the matter in the interest of all of us. I have at best had stonewalling. He's referring to this matter. He's referring to actions that are hitherto unexplained, which we submit are quite disturbing. And if this is not an attack on Judge Krikler, it's merely pointing out that what he has said may have quite deleterious effects on the independence of the judiciary in the event that FUL is accepted in this matter as a participant, a respondent, because they're not just a respondent, they're a respondent, however, to buttress the decision of the JSC. And we say that to the extent that the FUL wants to associate itself with the JSC in these proceedings, given this context, that might mire the very independence of the judiciary. And we ask the court to take that into account. Our learned friend further keeps on wanting to create this atmosphere about President Hlophe and the statements that were made previously. I've already addressed this court in the address, in my earlier address, that those matters have been finalized. Those matters were dealt with in court. They were dealt with by the Judicial Conduct Committee, and they've been finalized. And really rehashing matters that have been finalized by the constitutional bodies is not appropriate. We submit with respect. And we ask this court not to take those submissions into account when dealing with this matter. And lastly, my lords, my lady, reference to a constitutional court decision in Economic Freedom Fighters versus Godan and others, Public Protector versus Godan and others. It's a matter we refer to at paragraph 17 of our heads of argument in the intervention application, where the Constitutional Court said, "This matter has garnered much public interest and criticism. It is a matter which has a political bite to it. It is thus understandable why the public would have an interest in it. However, it must at all times be remembered that courts must show fidelity to the text, values and aspirations of the Constitution. A court should not be moved to ignore the law and the Constitution and merely make a decision that would please the public." We submit that our learned friends' submission to this court seek to do just that, to create hype. And the danger to that is to distract the court. And we ask the court to really determine this matter on the principles, on the legal principles, without the hype that has been created, which detracts from the real issues being dealt with properly. My lords, my lady, those are my submissions. Unless there is anything else, thank you.
Thank you, Mr. Sidaki. Anything from my colleagues?
No questions from me, thank you.
No questions from me, thank you.
Okay, okay, thank you. Gentlemen, thank you for the submissions that we've made. I think it's one or both of you quoted the CC case, which says that this matter involving JP Hlophe should be finalized without further delay. We'll try to do exactly that, and a judgment would be delivered within the next 10 days. It may be earlier. Thank you. Court adjourns.
As the court pleases.
As the court pleases.